Hello and welcome to everybody who has found their way here to the maritime room. I'm glad it's not called the Titanic room. And maybe we'll get back to the theme of the Titanic at the end of this, the first round of this panel. We, that is Deutsche Anwaltverein, the German Law Association, was doing this panel jointly with Privacy in Germany, Ping, which is a law magazine that I happen to be the chief editor of, and Markus, who I will introduce in a minute, is also on the editorial team. And we've been doing these joint panels here at this wonderful conference for many, many years. When we were thinking about what to offer as a topic in 2026, that was around about October, November, there was, at least in Germany, a very lively discussion going on about GDPR reform. In a number of circles, there were these discussions about what to do and what could be a good idea to touch. This was before the Omnibus. Chances were still at the time that there would not just be an Omnibus, but a more comprehensive GDPR reform. So what we'll be focusing on today will not so much be the Omnibus, but what might be a good idea to touch on top of the Omnibus proposals that we will, of course, talk about here and there today, but that will not be the main focus. And we will especially have a look at consent. As we are all aware, consent is very much again the option number one as far as Article 6 GDPR is concerned, because the ECG has narrowed a lot the other two options in the private sector, which is consent and legitimate interests. First of all, I would like to introduce to you Meryl van Aar, associate in Amsterdam at Field Fisher and an expert in data privacy, not just a practicing lawyer, but also a lecturer at the University of Leiden. Let's talk first of all, Meryl, about your view on the practical challenges in connection with consent. When do you, in your practice, what are the occasions when you are struggling with consent?
Yeah. So first of all, what I see in our practice, and we work mostly for companies that are operating in multiple countries, is that a lot of non-European privacy laws are more consent focused and don't have legitimate interest as a legal basis. So sometimes we're talking about consent when we really shouldn't be talking about consent. And then there are different examples where consent can be tricky. And I was thinking to myself, what do all of these projects that I've been working on over the years have in common? And what they have in common is that has always something to do with different implementation of the GDPR on a national level, or different enforcement of the GDPR per regulator. And I think if we look at the aim of the GDPR, one aim is, of course, to protect fundamental rights, but a second aim is really it's an internal market instrument. And this sometimes gets lost in translation. And one example where we really encounter a lot of problems with this, or where clients are really struggling, is in the life sciences industry. So for example, if clients want to conduct a clinical trial, they need, first of all, based on the clinical trial regulation, they need an informed consent for that. But in clinical trials, of course, you're also processing health data. So it could be that you also need an explicit consent in terms of the GDPR. And what we see here in practice is that patients are already a group who are more vulnerable. So this in itself could question the validity of the consent. And on top of that, what we see is that some countries, it's possible to process these data for clinical trials based on public interest or health. But in other countries, for example, in Spain and Italy, there's explicit guidance from the regulators that you have to ask for explicit consent. So in practice, this means that our clients want to roll out multiple jurisdictional projects, but the legal basis can be fragmented, and this can lead to fragmented data. And from a very practical point of view, also for the people that are participating in these clinical trials, it can be confusing to have the explicit consent and then the GDPR consent. This is one example. And the other areas where we see this, but it's more or less the same, is in the employment context, of course, and the age thresholds for minors. I think these are the most important areas where we encounter difficulties.
Thank you for this first impulse, Meryl. And now let's turn to Christopher. Christopher has at least two hats. He has been a practicing privacy lawyer for, believe it or not, 40 years, as he told me again last night. Unbelievable. But he's mainly now a professor of privacy and information at Queen Mary University of London, and we've known each other for 3 decades, unbelievably. And I thought it might be a good idea to have somebody on the panel with a non-EU perspective. So that was really the idea. And then we had a conversation last night, and which threw me back to the EU, because we talked about how consent became popular all over Europe, and this has a lot to do with the EU. And so, Christopher, could you just let us know what the history of consent in Europe is?
Thank you, Nico, and thanks very much for allowing me to come back after the lively discussion we had 2 years ago on red lines and so on. Yes, so I've been asked to do 2 things: be the old guy who remembers the history, and be the British guy, and we won't talk about Brexit. Please don't, it makes me cry. Okay, so when I started as a data protection lawyer in 1982, consent was not on the horizon as a legal basis for processing. The big novelty at the time was the Council of Europe Convention 108, the original text, which didn't even mention consent for processing. In fact, it didn't list lawful grounds for processing. It just said processing must be fair and lawful. We had to wait till the 2018 modernized Convention 108 for consent to suddenly be in the spotlight. In the meantime, of course, we had the EU Data Protection Directive, in which consent was listed as one of 6 equal, in my opinion, legal grounds, equal in status at least, for justifying the processing of personal data. In the meantime, the first national data protection law on which I had to give legal advice was the UK's Data Protection Act 1984, which was the basis on which the UK ratified the Council of Europe Convention. Again, no reference to consent as a basis for lawful processing. So, of course, we now carry all of this over to the GDPR, still has the 6 grounds, in my opinion, still of equal status. Meanwhile, if I can quickly contrast the position on the other side of the pond. So all throughout my career as a data protection lawyer, I have had close contacts with US colleagues, both in academia and in legal practice, who specialize in privacy. And we've had many lively debates over the years about why they are so stuck on this notion of notice and choice. And indeed, I asked my good friend Peter Swire again yesterday, why is it you guys still hang on to notice and choice when it so obviously doesn't work? He said, well, I'm afraid it's the only thing that Republicans and Democrats can agree on. It's because for the Republicans, it's a libertarian, you get the choice. And for the Democrats, well, it's better than nothing at all. So maybe in the next round, I'd like to say a little bit about whether consent works at the moment, whether it has a future.
Thank you, Christopher, for taking us back to 1982 or 1984. And may I now introduce Christiane to everybody here. Christiane is one of the ladies where I always wonder, where does she sleep? Because you're so proactive, and especially when you have a civil law background. You're a professor at Vienna University. And from a civil law perspective, you have more and more turned your attention to data privacy, and especially in the last years. You published a proposal for reform of dealing with AI, and especially AI training in the GDPR. And lately, you have published another more comprehensive paper on red lines and alternatives to consent. That I don't really want to say everything that you may be wanting to say yourself. So let's turn the mic to you, Christiane, and to the question of alternatives to consent from your perspective.
Well, first of all, thank you so much, Nico, for having me here. And just to say that I don't believe in that private law, public law divide. So for me, it's just law and maybe beyond law.
You've been away from Germany too long. Yeah.
I realize sometimes. Okay, no, really, I mean, I don't want to do away with consent actually, but what I'm concerned about is this focus on consent. I mean, it's no longer I mean, theoretically, you're absolutely right. Those legal bases in the GDPR should theoretically be on equal footing. But when you look at Court of Justice case law, in particular in recent times, when you look at how people approach GDPR, it's treated like the gold standard. And that is
one of my lines for next time.
That is simply not, I think, what is adequate. And there would be many other competing models. You already highlighted historical models which we've had. There are also other competing models. I just want to mention one of them. And I will start actually on the other side of the pond, because there is one US model law which is on nobody's radar, actually. It is the ULC Uniform Personal Data Protection Act. Now, what is that? The ULC is the Uniform Law Commission. That is where all the law, the states gather and try to formulate uniform model laws. And in 2021, they published that Model Uniform Personal Data Protection Act, which I think is a really interesting model law, because it takes that, what I call the traffic light approach, this red, amber, green approach. So you have like 3 categories of data processing activities. You have the prohibited use, you have that's blacklisted, you have the compatible use, which is whitelisted, and then in between, as a residual category, if you like, it's the incompatible use, and only for that you need consent. And so this, I think, is, in general, I don't like everything about that ULC law. It was a terrible failure because, right as you said, for the Republican states, it was going too far. For the Democrat states, it was not going far enough. So it was a terrible failure. Not a single state adopted it. But I think it's a really interesting piece of legislation. And at the European Law Institute, for which I'm quite active, we actually sat down and designed we drafted possible amendments to the GDPR that could bring a more risk-based approach into the GDPR. And it's also based on prohibited practices, on whitelisted practices, and on consent in between, but consent plus. But I can talk about that later.
Thank you very much, Christiane. Now, last but not least, may I introduce Markus to you? Meryl, you briefly mentioned that when talking about consent, in Europe, in the EU, you have to meet 27 standards, which may be similar, but may also vary a lot, which is one of the issues in data protection that we are struggling with. That the idea of the GDPR to have just one standard for all of Europe is not really what we always meet in reality. And in Germany, we have a particular situation because we have, as many of you will know, 18 DPAs for each of the Bundesländer of one, plus the federal GDPR, the federal DPA, and Markus is, well, I'm always jokingly saying he used to have a proper job. He started out as an associate at CMS, similar to Meryl, but then changed sides and is now based in Hamburg and working for the Data Protection Commissioner in Hamburg as the data strategy advisor, something that not many other DPAs have such a position. That is your position, and you have been involved and very actively involved in a paper that the Hamburg DPA did together with the DPA of Schleswig-Holstein, which is up in the far north of Germany. The Bridge Blueprint paper, 6 pages in English, advice to everybody to read it, where you did not focus on GDPR reform, but you focused on how the GDPR might work in connection with AI, even if it is not touched. This was published in September, and we were very happy at Deutscher Anwaltverein to host an event where this was introduced to the public last September. And frankly speaking, I was a bit skeptical if this might work, and I believed that a bit more on Christiane's lines that we would need to touch the GDPR to make AI and the interaction with the AI Act workable in practice. So, well, who was right? Was I right or were you right?
Well, I'm going to answer that now. So maybe to start off my job, like what is a digital strategy advisor? That's a weird title for a DPA. So what I do is I basically reach out to stakeholders, I reach out to people in Brussels, I try to do foresight for our DPA so that we know what's going on. And this has developed into a role where I basically do foresight for all DPAs in Germany, just because often the stuff comes up in Hamburg first, and then we kind of disseminate the information so that everybody's kind of up to date. And so when it comes to the Omnibus, I basically just sit down with people and try to, figure out what the hell is going on in Brussels. And so basically, I want to kind of fill it in. What is after Omnibus? Like, what's going to happen even? Does it make sense to talk about a reform? What's even on the table? And now after the AI Omnibus is passed and we now have a provisional agreement, people are asking, okay, so we're kind of done, fine. What about the digital Omnibus? And it's funny because we're in a limbo. Nobody really knows. It's basically mainly rumors. So I sit down and I ask, okay, so what's going on? Well, we won't be done till the summer break. Okay, so it's fall. Well, yes, it's fall, but you know what? The Commission has actually said that now they want to do an impact assessment of the Omnibus. Finally, they didn't. They should have done it in the beginning. Okay, but what happens then to the negotiations? Well, they might go on for a little bit longer because after we have an impact assessment, the Regulatory Scrutiny Board has to assess the impact assessment, and they will probably reject it because it will be a bad impact assessment. So then the Commission will have to redo the impact assessment, all while the negotiations are still going on. Okay, so what does that mean? Do we have an omnibus in 2027? Well, yes. You know what's funny? There is a digital fitness check that is going on. Yeah, I heard of it. A lot of people in Germany are really counting on that. But what is that exactly? Well, you have to take a look at the better regulation guidelines. And if you take a look at the better regulation guidelines, you will see that a digital fitness check is really just an evaluation of more than one act. It's not a legislative proposal. It's not a Hail Mary. It's basically just looking at the laws and seeing how they interact. No draft will come from this immediately. Okay, so you're saying that because the omnibus is stalled, and then the digital fitness check, where we already had all the comments get in, will be published in 2027 in Q1, those work streams will be in parallel? Might that influence the negotiations on the digital omnibus? Oh yes, for sure. For sure. They would then have additional amendments, so they fix the things that are in the digital fitness check. Okay. So what does that mean? When will the omnibus pass? Oh, maybe in 27, but could be 28 too. But there are elections in 29. Yes, that's also true. So the Commission's term runs until 2029. The Parliament elections are in June 29. A legislative proposal, in the best case, let's assume that the omnibus passes in time. A legislative proposal that will take basically the omnibus and the lessons that we learned from it, take the digital fitness check and take the lessons from it, and then say that we do a comprehensive reform of GDPR would take 2 years. So my educated guess is, I'm right. It will not happen. And we should really deal with the law that we have right now and try to get creative with it.
Surprise, surprise that you're saying your guess is that you were right. Christiane, we were recently sitting together in a called think tank committee hosted by the University of Munich and Boris Pahl there, where we were also, and where your boss was involved as well, Thomas Fuchs, and where we were sitting on we were working on proposals for GDPR reform. That work was finished in December. And now question to you, are you as pessimistic as Markus? Because what the consequence would be if Markus is right, would be that we will have to shelve all our work that we've done recently on reform and wait what happens in 2029. So chances are that we will have to wait we have to shelve everything till 2030. Would you be so pessimistic to agree with Markus?
Well, I'm not as pessimistic. I mean, I fully
Somewhat
agree.
pessimistic.
I fully agree with Markus that, a mistake in particular academics are making all the time is that they want to write great papers where they, say we need to change the law because the law is bad, we need to law reform, so on. And instead of doing that, because it's so uncertain whether the law will ever change, it's often a better strategy to advise the courts and everybody else how to do good things with the laws you have. So this is where I absolutely agree with Markus. On the other hand, am I as pessimistic? Well, if I was as pessimistic, I wouldn't have drafted all these proposals. I was not only a member in that group, but also came forward with fully drafted proposals, both on my side and then on with the European Law Institute came forward. And in my experience, often things turn out in an unexpected manner. I don't want to talk too much about a different topic, but I remember how things were with sales law. In 2015, Commission came out with a new consumer sales law proposal, and I was rubbing my eyes in disbelief. I thought, what? You come forward with a new consumer sales law, and you have nothing digital in it. And even making things worse, for the first time in history, you have create a divide between the digital stuff and the sale of goods, just as goods are getting connected and all sorts of digital elements. So I sat down and drafted alternative and I filed them with the commission and so on, and we publication after publication. They always told me in Brussels, well, Christiane, you're absolutely right, but we can't take that on board because it would jeopardize our legislative procedure. So we need to rush and so I had already given up when in 2019 I suddenly got a call, Christiane, can we get your last, what was your last proposal? And can we, and then it went through, right? And so sometimes things work out unexpectedly, and so I'm pretty relaxed. But again, I would agree with Marcus that for the time being we should try to do with the GDPR what we can do.
So maybe that is influenced by your long years in Austria. Is this more optimistic view? Because in Austria sometimes procedures are very complicated, but then there are quick results. Let me get back to the title of our panel. There's the word red lights, and you already touched the issue of red lights. And I have a question for all of you on the panel. One thing I have never understood about European data protection is why why there's really no processing of personal data, no processing of very sensitive personal data that would not be permitted by consent. Why? And I don't want to go into examples here, but everybody can think of examples themselves. There are outrageous. You could have outrageous ways of processing health data or other sensitive data, and the law never says this is banned, this is prohibited, but it always says no but, and at the end of the but there's always informed consent. And the simple question is, have you understood why that is so? Does that make sense that we don't have red lights in European data protection law?
I think you're looking at me.
Yes, I am, Meryl.
Yeah, I think that's a great question, and sometimes I think the reasoning of some of the regulators is that you need consent because people need to be informed, and in other areas they can say like, no, consent isn't the right approach because this is too sensitive, so you need to rely on legitimate interest. So yeah, and it seems the reasoning can be, if you look at e-privacy and GDPR interplay, the reasoning is more like no downstream processing on legitimate interest. And the UK ICO said for clinical trials, for example, like it should be legitimate interest because it's so sensitive. So.
And may I get back to you, Christiane, simply because I know your answer already. Does it make sense that there are no red lights?
No.
I think there are. Sorry, can I be contrary? Go ahead. No, go ahead.
I think it depends on exactly. I mean, there are two ways you can get, at least two ways you can get red lights in. I mean, the fairness principle would be one. And then, and now I put my other hat, the private lawyer, the consumer lawyer on again. And I mean, there's the unfair contract terms directive. The problem is just that courts in many jurisdictions aren't using that tool. But theoretically, you have a reference in the recitals to the GDPR to the unfair contract terms directive. And if you use that tool in a consistent manner, you could really prevent bad things from happening. But again.
I would just add to that I think that the concept of fair and lawful from the original Convention 108 is flexible enough to deal with this. Because if you see lawfulness not just as some internal thing within data protection law, but lawfulness more generally, then there are lots of red lines. So anything which is illegal in terms of processing data outside data protection law is arguably not lawful for the purposes of data protection law. And this could be defamation, it could be criminal law, it could be child protection, it could be any number of other laws. So I do think we have red lines, it's just that they're not in the data protection law itself.
And maybe to add on that, that is by design. And so if you look for red lines in the GDPR, I think it's just the wrong place to look. At the same time, I would say it's a bummer. It's a real bummer that that we have now an Omnibus and a digital fitness check, and we won't have like a real value choice of what kind of future we want to have, what kind of red lines we should have, what kind of green lines we should have. But there are green lines and red lines, and especially red lines if you look at other acts. If we say consent shouldn't be there when there's a market dysfunction. If we say there shouldn't be consent when it's about children, look at the DMA, which says consent is not enough then. Look at the DSA, who says for minors, consent is not enough. Yeah. You have these regulations, but the problem is that we are not being creative enough because we have this kind of silo view. We look at the GDPR, just as you said, and you probably also agree, and you agree, everyone agrees. We need to get creative as DPAs, as well as practitioners and deployers, to look at the vast body of law that we have, unfortunately or fortunately, and say, okay, let's have a look. There are value decisions all over the place. We just have to find them and connect them to the open terms that the GDPR has, to substantial public interest, to legitimate interest, to legal obligations, or, as Article 5 says, only legitimate purposes of data processing are legal, meaning illegal cannot be legitimate. So as per Article 5, no data processing is permissible. Like, you can find these connections, you just have to look for them.
Can I also come back quickly on green lights?
Not everybody, just let me throw in a remark, not everybody in this room, not everybody in this room has heard the words DPA and creative in one sentence.
I was just going to say there are green lights too. So one of the justifications for all kinds of processing activities, it could be collection, it could be transfer, it could be disclosure, sharing, is that it's required by law. And again, you look outside the data protection law to see, well, which law requires me to do this? And at that point, you may find you have a green light. So we do have red lights and green lights already.
Yeah, I do agree. I mean, a problem is that those green lights are often fragmented across the European market because it's mostly then national law. And coming back to what you said, I absolutely subscribe to that. But we also need to look at those vast other bodies of law which you mentioned. And then I put out my private law hat again. Sorry for that. I thought
you don't distinguish between private law and public law. What's
exactly,
going on here?
Oh yeah. You're absolutely right. So just my hat. Okay, but we do have a problem in those other areas of the law too. And for example, tort law, as it is understood by the courts in the various jurisdictions, is simply not fit for the data reality. And so this is why what the European Law Institute at the end of the day drew up as a list of prohibited data practices, really what that is a data tort law. And it's you could do that at national level in your national tort law, right? And then you would have, via the kind of link of lawfulness of processing, you could say, well, that's simply unlawful and it's not possible under GDPR either. It's just you'd need to do it somewhere. And as we don't have tort law harmonization, and there's arguably it will be difficult to have a legal basis and all of that, it may be a good idea to have it then in the data protection law itself.
But you don't want to take away too much work from lawyers. No.
Oh, no.
Christiane, could
Never.
you just explain briefly what the European Law Institute is? Because not everybody in this room will be aware of it.
Oh, the European Law Institute is a pan-European organization founded in 2011. It was modeled on the American Law Institute that had been shaping US legal development for over a century. So the idea basically is that you have lawyers coming together. And with lawyers, I mean lawyers from all professional backgrounds. So not just academics, but mainly practicing lawyers, judges, government lawyers, and so on. And they basically create a platform for not just discussing things, but also shaping European legal development. That means drafting proposals, model rules, principles that are not created in a top-down manner, like in the EU institutions, but like in a bottom-up manner, because it's lawyers from all over Europe gathering and creating something which they believe would be beneficial, and everything that's published needs the approval by the council and the whole membership. So, and yeah, that means that what the ELI does is maybe often not as flashy and whatever as some of the proposals you get from politicians, but it has the support of a really broad and heterogeneous constituency. And so, much to my surprise, our suggestions how to reform the GDPR got that approval. So it seems like a lot of people in Europe are thinking in a similar way, but it doesn't really reach the legislator always.
Okay, it's a must read for everybody who is not just interested in the GDPR as it is, but also interested in the GDPR as it might be. It's easy to find if you just Google it with your name, Christiane, and the ELI, and it's very recent and very thorough and good paper. So a firm recommendation. Let's just go back to consent for a minute. There's possibly a strong German element in it. If you ask sort of average educated Germans what data privacy is all about, the answer will be, well, that I have to be asked when my data is processed. That is the sort of simple but very, very common notion of what data privacy law is all about. May I ask you, Christopher, if this is as German as I might have the feeling it might be?
Well, we debated this a little bit yesterday, some of us. So obviously, Spiros Simitis, one of the founding fathers of data protection law, was very keen on the idea of informational self-determination. Meanwhile, again, if I cross the pond, we had Alan Westin really adopting a pretty similar approach in terms of providing information and giving people a choice. I've already said why I think that may be difficult in practice. But I think the problem now is that consent has been so overused. It looks like an easy fix. Oh, I'll just give them a notice, get them to tick a box or whatever, that it almost never works. And the irony is, it's often not necessary. I think most processing can be based on one of the other 5 lawful bases for processing. And so consent has been kind of done to death because it's used all over the place, inconsistently. The reasons why it doesn't work are well rehearsed. I won't go into the details, but obviously most people don't read the notices. If they did, they probably wouldn't understand them. Often they're inconsistent. You don't know how to revoke the consent, which should be as easy as giving it, et cetera, et cetera. There are all kinds of practical problems there. But I think it's just one tool in the toolbox, as I said at the beginning. It's been overused, and it's actually kind of been wrecked because so many people try to rely on consent. And in case there's time for a further round after this, Nico, I'll throw out one more thing. I think we shouldn't forget what Helen Nissenbaum has called contextual privacy. So it's not just I consent once to this person for this reason. I have lots of information that can be used by lots of different people for lots of different purposes at different times, in different places, in different contexts. How do you manage that with consent as currently envisaged? And I don't think it's easy to do, but there might be a technical angle on this in the context of agentic AI, which I'm happy to talk about later.
Meryl, Christopher just said that consent almost never works. Mm-hmm. Would you agree?
Yeah, I completely agree. I think consent is a false friend often. Maybe it can work for a newsletter or like a survey that you do online and it's clear what you're consenting to. But I think can be a false friend. Yeah.
And Christopher also agreed that there is a strong German element, if you look at the history of consent in European data privacy law. So we Germans would need to defend consent, really, or what do you think, Markus?
So I think that this consent fixation has a lot to do with the maturity of data protection law. Yes, all bases are equally relevant. All bases are equal. I'm also of that opinion. Meanwhile, in 2018, many of those bases were so open and so unclear on how they function with other laws together. And we had no clear regulation in the GDPR, except for maybe Article 95, which wasn't clear enough. So the CJEU had to decide on it. But people weren't aware, like, how can I use this? Is a legitimate interest just me saying it's legitimate? Does it need a balancing test? What kind of balancing test? How long should it be? Those questions were not answered at that time. And it was difficult to answer. And so when you have this kind of uncertainty and inconsistency, at least a perceived inconsistency, because some laws were there, as you mentioned, then you default to something that is tangible. And someone ticking a box or saying yes is tangible. So I understand it from a human perspective. I understand this consent fixation. And from a German perspective as well, because we like tangible, ordered things. And a legitimate interest assessment is seems like what to a German? Like, what does that even mean? And so I think that consent in that way has expanded into areas it was, as you said, was never designed to cover. And what should be there instead should be this creativity of thinking, okay, consent is something that we use when we do not have a value decision by the lawmaker or by judges. So it's there to fill a gap. Yeah. Do we really have a gap? That should be the first question. And that question should be followed by rigorous research, looking at the laws. Is there really a gap? Has the legislative branch really never had this question in the analog world before? Most of the time, the answer will be, no, they did already do this. There was already a discussion on this, because most of the problems that we have in the world are now just being repeated in the digital world. Most of the time, you just have to be like, take a step back, basically, and look at it. And then most of the answers come up.
Can I pick up on that briefly?
Just one remark. So this is really, well, surprising to hear from a regulator. This is turning around really what the gold standard thing.
Yes.
Because what we would normally, the way we would normally see it, is that consent is the gold standard. And if, for example, in connection with AI, we have an issue with gaining consent, the other five alternatives are the gap filler.
Yeah.
And you're saying exactly the opposite. Yeah.
And I was going to talk about gold standard, so I'm glad you raised it again. I totally agree with you. For some obscure reason, regulators and many practitioners do believe if they can get a consent, that's the best possible thing. Actually, it's often the weakest and the most unreliable, the flakiest from the perspective of the data subject, and the most volatile from the perspective of the the controller. So take, for example, in the HR context, give a practical example. Some employers try to get their employees to consent to various things for which they do not need consent, because it is required by law. They need to process the data for payroll or for compliance or for some other purpose. If you get a consent, you weaken the whole structure, because remember, the individual employee then has a right to withdraw consent just as easily as they gave it. So where are we left then? What happens if it was something you were allowed to do anyway, but someone's given you consent and then they've taken it back? It's a real mess, and that's why I think consent has been massively overused, and it's not the gold standard.
And maybe to add on that, I can see how, especially from a German perspective and the right to self-determination kind of standard that we have in our own constitutional law, we think of consent as something that will definitely be enough because the individual has kind of allowed for this infringement. And in the end, the consent is the one thing that is named in Article 8 of the Charter. So it's something that is reliable because it exists and it is tangible. At the same time, we shouldn't forget that, for example, if you look at legitimate interest or if you look at public interest, there's the right to object. Mm-hmm. And so if we have the right to object, we kind of go into the same mode of like there's a withdrawal, and then in the end, when we have a withdrawal consent, you can't do anything about it. But at least when you have an objection, you have a conversation. And I think that that makes a big difference and is actually the better tool to kind of have a conflict resolution in that sense. And to just give you an example of where I think that it wouldn't make any sense to basically rely on consent, and the legislator has already seen that, is, for example, and then you can jump on AI, but is bias testing in AI. So they saw, okay, Article 9, we would probably need consent for bias testing en masse. Does that make sense? No, it doesn't. So we write this kind of Article 10, Paragraph 5 of the AI Act. Now the criticism is, okay, is that even an exception to Article 9 because it isn't explicitly linked? Like these legalistic kind of things are the wrong mentality to meet this, because it's obvious that the protection of people and the protection of people against discrimination needs this. So there's a green line in the AI Act. We do not rely on consent. We take it into the exceptions of Article 9. And then people always argue, well, but it's only high risk. So what do we do about this? How do we get like a mass of anti-bias kind of training? And the answer to that is, again, a value decision. We have anti-discriminatory laws. We've had them for years, and we are very, very educated and experienced with dealing with anti-discrimination. So the question really is, if we have a legal decision that says we need anti-discrimination and data processing for that purpose is necessary, why do we talk about consent?
Before continuing on sort of examples and issues in connection with AI and Article 9, Christiane, I have one question, and I'm very sorry, this touches again the difference between public and private law. Self-determination, that is something German, and I'm aware that if you're not from Germany, some of you always have an issue of understanding what this is all about. This is the fundamental right created by the German Federal Constitutional Court in 1983, so that's even more than 40 years ago. And this was on a case of the state collecting and processing data. And in Germany, sometimes the discussion about self-determination is very superficial. And when you superficially discuss self-determination, it's more or less natural that self-determination means, well, I have to be asked. Have we maybe gone wrong by just taking a rule, self-determination, in connection with the state collecting data? If we take a rule and just blindly transferred it to private data processing, although there are, in contrast to issues in connection with processing data by the state, there are other fundamental rights and issues involved.
Well, it's funny you're asking that question. We didn't discuss it before, but I gave a talk 2 days ago in Berlin where I took exactly that position, that I said, well, I know even the earliest data protection laws in Germany already included private-to-private relations, but the whole mindset is a kind of public law mindset, right? Where the state kind of intrudes upon people's civil rights and so on and so forth. I was not everybody agreed with that idea, but I would say yes, that is still the mindset that is behind all this thinking. And I was arguing for having, a kind of really across the board private law, solid, robust foundation for the digital economy, which we don't have at the moment. But if we are saying data is the new oil, it's what makes our economies run, then it's really strange that our private law really doesn't or pretends not to deal with that, right? It would be like we have a private law that doesn't deal with goods. No, everybody would say you are insane to have a private law that doesn't deal with goods and property and ownership in goods. And so why do we believe we can have a private law that doesn't really say how to treat data and so on and so forth. So yes, I would very much agree with that approach, but it was controversial in Berlin. I got quite some pushback from some DPAs.
Christopher, what is your view?
Yeah, thank you. I'd like to look at a slightly different aspect of this, which is the whole question of practicality. I'll always try to be a little bit pragmatic. And I don't think the current system of using consent works, not just for the issues of principle that we've discussed already, but from a purely technical angle. Because information, supply chains, ecosystems, whatever you want to call them, are immensely complicated. We've seen with the attempts to regulate the ad tech industry and the attempts to use consent in immensely complicated systems with thousands of participants and long supply chains. And many of you will be familiar with the IAB case and the transparency consent framework, and the idea that you have TCF strings and somehow you can follow it all the way down back to the individual and say, oh, they gave consent, that's fine. I don't think that system really works, but you ain't seen nothing yet because agentic AI is round the corner. And I don't just mean an agent that you say, oh, book me this thing and use my credit card. I mean a complex ecosystem, lots of agents that are executing a broad goal with considerable flexibility and discretion, and some would say authority in how they do it. There may well be another agent, which is the orchestration agent, which tries to manage all these agents that are off doing things for you. One of my favorite concepts in agentic AI and data protection is the idea that you can have some kind of guardian agent, which is like the DPO. I think it's a bit more funky than being a DPO, actually. You want to be a guardian agent. And the guardian is there to make sure that all the rules of the game and all the data protection compliance issues are respected. But this is going to be an order of magnitude more complex than what we've seen, for example, in ad tech, where the system has already started to break down, if not completely broken down.
This comes very close to please have me the trusted.
Joseph Seigert?
Sorry?
No, what?
Well, something that our federal DPA is very much favoring, to have an agent, who is exercising the right to consent or not, and these agents being private players that are certified by this by the DPA. We do have one such certification in Germany so far, and there's something in the Omnibus also to support these solutions. And I think it comes very close to what you are saying, except that there is more technology involved.
Well, that's a good point there. The fact there's more technology involved. So it's not just can you as a controller accept a consent from my agent. It's can my agent deal with your agent? And actually there's a whole bunch of sub-agents in the chain. And in legal terms and in practical terms, does it make any sense to say that there is consent for a particular processing activity? Bear in mind, these are very dynamic. So you might have a swarm of agents off trying to pursue some kind of goal, all doing their little bits of tasks. And suddenly, one of them will find out they've been given some information by the other party's sub-agent. And does it change the whole rules of the game? Do you have to go back to the guardian? Do you have to give more information, transparency, get another consent? I just don't think it can be scaled like that.
I have always had my doubts whether this is really an attractive business model for companies. But I may be wrong. What is do you have an opinion on that, Meryl?
Yeah, I think in general, I heard a lot of what I really liked, what Marcus said, like sometimes it's also good to take a step back. And I think if I'm looking at the people in the audience, the chances are very likely that you heard one of us say something that you don't agree with. Because there are a lot of different ways of looking at things, and just we are here, it's competing visions. And one of the things that I found the easiest thing of the word is to disagree with something, right? There's always something you don't like. But we're also looking here at shared futures. And one thing what I would like to do here also on this panel is just to take a step back, because when I'm advising clients, they are looking at legal terms, what may we do, but also like technical terms, like what can we do in practice, and also what do we want to do as a business. And we are talking about legislation, regulation to protect the people better, to protect people more, and this is wrong, that is wrong. But if we look at the European vision, we kind of agreed, well, of course, can have different visions on this as well, but one of our core aims at the moment is to commercialize European innovation and to really close the gap with US and China and to reduce dependencies. And just within the context of this panel, I would like to share this thought as well, that, you know, human rights are also better protected when we have a good ecosystem for European innovation and legal certainty. And I really like what Marcus said about getting creative with the law, and I hope I can quote him on that later with my German colleagues as well. But I think this is a very good point, and we all have to, like lawyers, but also the DPAs and academics. I think we should all try to cooperate and work together on that as well.
I would bet that nobody in the room disagrees with you. Yes.
I stand to be corrected, so anyone.
Christopher, from a UK perspective, would you agree?
Yes, because I'm doing a lot of work, again, something I started in the 80s, but digital sovereignty and data sovereignty are very hot topics at the moment. And that's a very clear example of what Mel's just referred to, that if in Europe, and I'd like to include the UK for this purpose, even though we're not in the EU, if in Europe we want to have greater autonomy and less dependency on US cloud hyperscalers, less dependency on suppliers from other countries we may not trust, then we have to be realistic about what can be achieved. And if it is true that we are partly being held back in terms of innovation and industrialization because of the way some of these rules have been interpreted, perhaps more strictly than they needed to be, then I think we need to take a hard look at that, because what is the greater risk here? What is the greater good here? And I do fear that if you get into the sort of realms of privacy fundamentalism, I call it, and you treat this as just the only issue that really matters in life, that it can have some very negative, adverse knock-on consequences that may not be in everybody's interest.
So maybe just to quickly add on that, I mean, that is the right goal that we need to have, but at the same time, just saying we need to take a hard look at privacy or at data protection law and see how we can work with it so that it finally serves that goal. Yes, that is one part of it, but the other part is also that we need to spell out the goal. Mm-hmm. And I think that is what is lacking, really, because we do not have, like China, a 5-year plan. We used to laugh about 5-year plans. Mm-hmm. Now we look at it and are like kind of jealous. Oh, they have a hard policy that everyone has to follow. Yeah. If we look at the US, they have a clear policy goal: build, 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 be the first in AI at any cost. Yeah. And we do not have that goal. We know that we want to do it and preserve human rights and preserve privacy by design or data protection by design. And at the same time, we do not have that clear goal that is the goal. And at the same time, we need to innovate. And if we do not have any like tangible paper by the EU, which basically in short terms, and as a 2-page or whatever, tells us everyone needs to get on board. Every practitioner, DPA has to follow this. This is our consensus. Yeah. Then the other half of just scrutinizing data protection law isn't going to be enough.
I agree. I mean, digital sovereignty has been discussed in Europe since the 1970s. Again, putting my old guy hat on. In the parliament in Sweden, when the world's first national data protection law was introduced, which included restrictions on transfers of data across borders, the minister responsible gave a very lively speech in which, among other things, she said, being dependent basically on all these US tech companies is like walking down Fifth Avenue in our underwear. So this is from the 1970s, very feisty way of putting it, but it's not a new issue, this digital sovereignty. And in the last 15 years, there's been a huge amount of discussion in Brussels and elsewhere. And finally, in the last year, people wake up and say, oh, heck, I won't be rude, that this really is an immediate problem. The trouble is, you should have started 15 years ago. You cannot build a European hyperscaler in the next 2 years or 5 years, probably 10 years is more like it. And you're going to have to make a massive commitment and make significant sacrifices in terms of welfare budgets and other things. And this debate, we're really not on top of it yet. There's a lot of talk by politicians, but it needs a lot of action, and it's going to cost a lot of money, and it's going to be very controversial. And maybe it isn't quite too late, but we're pushing it.
Just two brief comments. If you ever have a chance of attending a speech by Christopher on digital sovereignty, if you just heard him, you won't be surprised if I'm making a recommendation now. Listen to it. Brilliant. Second comment. I happen to work and live in the east part of Berlin, which was part of East Germany. They always had in East Germany, they always had 5-year plans. They were always overfulfilled by at least 150%, but the economy still collapsed. So I don't really believe in 5-year plans. And now I'm going to do some baby steps towards closing this panel. If I may just ask each and every one of you, starting with you, Christiane, to just briefly touch on the one point that you have wanted to make all over the last hour, but haven't been able to do so yet.
Oh, well, that's really a hard one. Actually, the one point is maybe that we should stay optimistic after all, and that we're always talking about regulation as hindering innovation. And I would agree with what has been said, that maybe the major problem is that all this debate about regulation is distracting us from the really important things we should be doing, right? Because I don't see that Article so-and-so of the GDPR is the reason why Europe may be falling behind. The reason is that we haven't been doing the stuff we should have been doing outside the regulatory realm. So that's maybe my point.
Christopher.
Wow, thank you. Yes, well, a theme that I've spoken at before at this conference about a decade ago, the question of humans in the loop and humans on the loop. And again, I'd like to try to strike a slightly more optimistic note than you've heard from me so far. I've argued for a long time that the requirements of Article 22 of GDPR and the idea that you can get human review of automated decisions probably doesn't work in many cases. And there are the arguments are well rehearsed. I won't go into them now, but just as a possible hopeful light here, maybe if we can understand what we're trying to achieve in terms of goals, as Marcus keeps pointing out we must do, then it might be possible to use digital agents, agentic AI, guardians, whatever you want to call them, to do things that humans just cannot do in terms of review against policies, whether they be security policies or data protection compliance policies or whatever, in real time, in complex dynamic systems, in a way that it's never been realistic to have humans jump in and somehow do that. So I do think, and I don't want to be sort of techno-utopian about this because I have serious concerns about the technology, but there may be ways we can use the technology to help us do things we couldn't actually practically achieve before in terms of governance and protecting individual rights.
The human in the loop and Article 22, which is old because it was more or less identical in the directive of 1998 when we're not talking so much about AI. The human in the loop is a good example for consent because the human must be in the loop unless the data subject consents. What is your one point that you have been waiting to make?
So, I mean, it's more of a summary of the points that I was trying to make, but basically it's think big, act small. Think of the goal. Same thing we did with the bridge blueprint. We need to make this work. What are the pain points? Let's get to solving them. And one thing that really helped me in solving these is recital 41, I will act small, recital 41 of the GDPR, which says that as a legal basis, laws are not only parliamentary acts, but also basically anything else that is as clear as a law. So it can be a judgment and it can be anything. And the court, the CJEU, regularly references, for example, judgments by the European Court of Human Rights and says, well, that's a law too. or it says there's an agreement between two countries. That's a law too. Take that and basically try to make legal basis happen by looking at value decisions that we have in court cases, in laws and bylaws, and just in legal traditions that we have in order to have the analog world that we already have with value decisions translate into the digital one.
Meryl, the one point that you have been dying to make.
I think my most important point is that legal certainty and alliance between national regulators and member state law will improve the protection of European rights. And if there's anyone in this room that is sometimes a little bit intimidated or scared because of all the technological changes and AI use, please know that in the UK, every 1 in 3 children circumvents age restrictions by drawing fake mustaches on their face. So that's it for me.
So now it is your turn as I'm opening the floor. And could you please ask the one question you have been meaning to ask for the whole session so far? And if I may ask you to be as brief as you can. Yes, please.
First of all, thank you for the panel and for the honest reactions about this topic. My question, I think that is very brief, but I think that is very complex, so I prefer to provide the time to speakers to address it. So I don't know if you are familiar with the European Health Data Space Regulation, which is going to transform the concept of consent, because the patients and all the EU citizens are going to have, depending on the member state, the right to opt out for primary use, and for sure the right to opt out for secondary use, which is actually very different from consent. So how do you think that this right to opt out is going to affect to the legal basis for process personal data and sensitive data as it is health data, even though it is anonymized or pseudonymized for secondary use of data, even though it is just the electronic health record for the primary use of data?
Tough question.
We're all looking at each other.
Yeah.
In the best case, it's going to revolutionize it. That's the point. I mean, I think the European health data space is the direct consequence of consent fatigue. And it is clear that if the example was made yesterday, if someone who has a skiing accident in Italy can have their health data from Germany being accessed in order to have a good, in order to being taken care of properly, then that's a problem. And if science cannot research such accidents in order to prevent them in the future by, I don't know, building ski slopes differently, then we also have a problem. And I think the legislative branch in the EU realized that both these problems cannot be our actual value choices by the European Union, and data protection law has to follow these value choices while paying attention to the data minimization principle. But data minimization cannot stand in the way of the goal. The goal has to be achieved with the least data possible. But if the goal is big and requires huge amounts of data, then that definitely influences data minimization.
And don't forget, data altruism is a possibility in health context. You know, maybe if people understood the good that could come from sharing their data, then we might be able to find a very positive basis for that.
You're right. There was one question. I can't quite remember which of the gentlemen it was. You were. It was you. Okay.
Hi there. Thanks also for the panels. Very interesting. Matthew Newman from MLEX. Here I am. A question for Marcus, and it's about the digital omnibus talks that are going on right now. There's a lot of frustration because the original proposal, which was by the Commission, hasn't gone in the direction that the Commission wanted it to. There's been a lot of pushback from member states. And I'm wondering about this, what you mentioned, the impact assessment, economic impact assessment. Do you know how important that is for the member states to have that? And it seems to be very, as you indicated, late in the process. Has the Commission actually agreed to do this? Because it would really make things quite slow, as you indicated.
So it's all basically rumors, is all I can say. And hush hush, maybe what I heard was basically there was some panel, the Commission officials might have said, and whatever. I mean, if it is going to happen, it's going to slow down the process. At the same time, yes, I would like to read an impact assessment because I do not think that all the rules of the digital omnibus were impact assessed. And if they would have been, we could have also done without them. And also an impact assessment is not only, it also looks at the baseline, saying what kind of rules would we have needed? What kind of rules could we have done without with? And I think there are some issues that could have been dealt with in an omnibus that were not even looked at. I'm speaking about, and across the board are being agreed on, from Max Schrems to the DPAs to practitioners, that, for example, data processing agreements need to be dealt with in a way that's less bureaucratic than it is now. And still, we haven't seen anything from that.
Can I just give you the British angle on the omnibus? So this is a very important concept in English law. We have the concept of the man on the clapham omnibus. Anybody heard of that? So this is the reasonable, the fictitious reasonable person in law. But we also have a statement that you can wait half an hour for a bus, and then a whole bunch of them come along at once. And I feel a bit like that about the EU omnibus. We're not really understanding what the reasonable man on the Clapham omnibus wants or needs. And we've got a whole bunch of these things all arriving at the same time.
In conversations last year, before the omnibus came out, I mean, these are two omnibus, the AI was mentioned, the data omnibus, but there are more to other issues as well. And we were given the explanation by representatives in the Commission that an omnibus was a very fast vehicle. So they would do an omnibus rather than sort of a GDPR makeover to move things fast. No further comment. Who wants to have the privilege of asking the last question in this panel?
Nico, there's somebody here.
Yes, so you're the lucky winner.
Thank you. I want to get back to the notion of consent and fairness. In this day and age of complex data processing, do you believe, and it's a simple yes and no, that processing based on consent can ever be fair?
Who of the four of you will be able to just say yes or just say no?
Well, in some situations,
That's
yes.
not a yes or no.
It depends.
Lawyers always say it depends.
We can say it at the same time,
It
all of
depends.
us.
We'll all say it depends.
It depends.
Meryl, be courageous.
Yes.
So this was in the history of famous last words. Meryl, thank you very much. Thank you very much to all the panelists, and thank you. I think they deserve a bit of applause.
And thank you, Nico, for excellent moderation.
Thank you, Nico.
Absolutely.